This is the second lecture for the Federal Courts, Chapter 15, and in this lecture we're going to be taking a look at the Supreme Court and the power that the Supreme Court has, the power of judicial review. So when you hear the words U.S. Supreme Court, what comes to mind? The Supreme Court's gotten a lot of coverage in the last couple of months, in large part because of the death of Associate Justice Ruth Bader Ginsburg and the confirmation of her replacement, Associate Justice Amy Coney Barrett. And there was controversy around the procedures for which Amy Coney Barrett was selected, in particular because when President Obama was the president and Antonin Scalia died, the Senate refused to confirm President Obama's nominee, Merrick Garland. But when Ruth Bader Ginsburg died, the Senate didn't have that same problem. So when you think about the Supreme Court today, you might think controversy, but just think what comes to mind. Also, what do you know about the Supreme Court? Do you know how many justices that serve on the Supreme Court? Do you know how the justices get selected to serve? You might be more familiar with that since we're just lived through that process. Do they have a length of term? If so, how long? And what kind of cases does the Supreme Court get to hear? Well, for this week, there is a Vox video explainer for you to watch about the Supreme Court. And it's a short video, but it does a great explainer, giving an overview of the Supreme Court, but also talks about how a case gets to be heard by the Supreme Court and the types of cases that the Supreme Court agrees to hear. So I really encourage you to watch it. Plus, there will be a question on it on our lecture quiz. The United States Supreme Court is established by Article 3. So the legislature, Congress, is established by Article 1. The presidency is Article 2, and the U.S. Supreme Court is Article 3. It says that judicial power of the United States is vested in the Supreme Court. It also tells us that when the Supreme Court can hear cases for the first time, in other words, what its original jurisdiction is. But for the most part, the United States Supreme Court serves as an appellate court. It doesn't hear cases for the first time, but it hears cases on review. The number of justices on the Supreme Court is not in the Constitution, but that power is given to Congress. And it has varied. The number of justices that have served on the Supreme Court at any one time has varied over time. But since 1869, it has been set at 9. However, and this has been in the news recently, that if Congress wanted to increase or decrease the number of Supreme Court justices, it has the constitutional authority to do that. There's one Chief Justice and 8 Associate Justices. The Chief Justice does not necessarily have to be a member of the Supreme Court in order to become the Chief Justice. For example, our current Chief Justice, John Roberts, he was nominated to the court to take the role of Chief Justice. He didn't work his way up from Associate Justice to Chief Justice. However, sometimes justices do work their way up. The previous Chief Justice, William Rehnquist, was an Associate Justice before he was nominated to become the Chief Justice of the Supreme Court. Now, when it comes to those other courts that we talked about in Lecture 1, Congress is the one who has the power to establish the lower level appellate courts, the U.S. Court of Appeals, and also the U.S. District Courts, okay? And so the number of those courts and the number of the appellate circuits, that has changed over time, and that is something that the Constitution gives Congress the power to do. So Supreme Courts they're marked historically by the name of the Chief Justice, right? And so, like, you might have heard of the Warren Court under Earl Warren, and the Warren Court was really known for expanding rights to the criminally accused. It provided actually an expansive understanding of many civil liberties, not just to the criminally accused. And so courts take their name from the Chief Justice. And so we are currently in what's known as the Roberts Court. And this is every time a new justice is added to the Supreme Court, they take like a school photo. And so this is the most recent school photo of the 9 justices that serve on the Supreme Court. Although, as we know, Ruth Bader Ginsburg just recently died and was replaced with Amy Coney Barrett, who's off in the side there. But as far as I know, a new school photo has not yet been taken. And this graph shows you the makeup of the Roberts Court. It has Chief Justice Roberts at the top because he is the Chief Justice. And so he, as you'll read in your textbook, the Chief Justice has a special like powers or special authorities. When it comes to conferences, the Chief Justice will speak first. And then they'll speak according to their seniority, the associate justices after that. So those who have been on the court the longest will go next. If the Chief Justice is in the majority of when they're determining a case, if the Chief Justice is in the majority, then they write the opinion or they select the person who is going to write the opinion of the court. And there are other powers as well. And so that's why it comes at the top. Now you'll notice on this graph that we've got the names of the justices, and then we've got their date of birth, so you can see their age. You can see what their job was prior to coming to the court, and then you'll also see who appointed them, okay? And then that gives you a sense. It's not how old they are that matters in terms of their seniority. It's how long they've been on the court. So, for example, the justice that has the highest level of seniority on the court is Clarence Thomas, and he was nominated by George Herbert Walker Bush, Bush 1, in 1991, right? But he's not the oldest justice. Stephen Breyer is the oldest justice at 82. And so you'll note that, that we have some older justices, but in the Trump's 3 nominees, Neil Gorsuch, Brett Kavanaugh, and Amy Coney Barrett, they're quite young, 53, 55, and 48. And that's sort of a trend that's happening in the courts, that since it's a lifetime appointment, you put somebody who's on there for young, because probability wise they'll be serving for a long period of time. And then this middle column shows you what the previous experience were. The vast majority of justices, their previous experience was that they were circuit court justices, and so they served on the U.S. appellate courts. That's usually seen as a stepping stone to the Supreme Court. The only exception is Elena Kagan, who served as the Solicitor General. That's the top lawyer for the United States. So if the United States is ever a party in a case, they will be represented by the Solicitor General. And she was the Solicitor General under President Obama. And then it shows you that their religions. And so the vast majority, and this is very strange, the vast majority of people serving on the court right now are Catholic. Catholics only represent about 25% of people in the United States. And then we have 2 justices who are a member of the Jewish faith. And Neil Gorsuch was raised Catholic, but he now is Episcopal. So check it out. It's sort of like when we're talking about sociological representation, that we see a little bit of a gap there in terms of religion. So Supreme Court justices are nominated by the president, and they are confirmed by the Senate. And the first step after being nominated by the president is that they're questioned by the Senate Judiciary Committee. So if you watched any of that, Amy Coney Barrett's Judiciary Committee hearings, those were televised and sort of of interest recently. And then they are confirmed by the whole body of the Senate. It used to take a 2/3 majority. This wasn't in the Constitution, but this was a Senate rule that you needed to confirm the justices by 2/3. But that is no longer the case. Now all you need is a simple majority for confirmation by the Senate. It's a lifetime appointment. And so once you are placed on the bench, you serve until you either retire, like Anthony Kennedy did, or you serve until you die, like Associate Justice Scalia and Associate Justice Ruth Bader Ginsburg. Both of them died in office. They can be removed. All federal officials are subject to impeachment, and that, like the same impeachment process that a president would go through, a federal judge can be impeached as well, although it rarely happens, just as it rarely happens with presidents. There's no constitutional qualifications to be a judge. However, there's norms that apply, and it's unlikely that you would get confirmed by the Senate if you didn't have the appropriate, educational background and the appropriate experience necessary to be a federal judge. But hey, never say never. And just the Supreme Court is in session from the first Monday of October until the very end of June. Although this year there's nothing in the Constitution about that. Okay, so these are all just sort of the rules of the Supreme Court that have been established over time. With the pandemic, the Supreme Court session actually extended beyond the end of June into July. They can do that if they want. But that usually it's the first Monday of October until the end of June. And if you're a geek like I am, or a nerd, I guess not a geek, but a nerd, hey, you might want to check out SCOTUS blog. SCOTUS is the Supreme Court of the United States. That's what SCOTUS stands for, like POTUS and FLOTUS. You got SCOTUS. Check out SCOTUS blog, particularly as hot cases are coming down the pike. So, as cases are announced, usually at the end of June, although they're announced throughout the term, some of the landmark cases are held and announced at the very end of the term. And so you can go to SCOTUS blog, and they do sort of a play-by-play of the announcements of the decisions of the court, and also give some really nice judicial analysis. So I encourage you to check it out. So the framers considered the Supreme Court to be the least dangerous branch of government. These are individuals who are not elected. They don't campaign. They don't have to serve for, they're not up for re-election. And so the thinking is that the judiciary was going to be really sort of apolitical. It was really going to be where you could have these objective analysis of the constitutionality of law, and that you would use the Constitution to sort of objectively evaluate and settle disputes. But now, the things have changed, okay? And so now some are sort of considering the Supreme Court not the least dangerous branch of the three branches of government, but the ones that actually wield the most power, and perhaps to the point of it becoming sort of a dangerous branch. And so there are recent concerns, and you're hearing this, in the news recently, about that the Supreme Court is being viewed as not an objective, nonpartisan, sort of, elite academic sort of, investigation of like the Constitution and the law that's sort of detached from the day in dirty politics that we see in the legislative branch and the presidential branch. But the recent concern is that it's becoming more like the other branches of our government, that it's becoming a partisan institution, that we see that cases are often determined not with unanimous decisions, particularly really a landmark case or highly sort of controversial cases. And so it seems like judges rule according to either a conservative philosophy, a conservative ideology, or a liberal ideology. And so that, when you have a president who's more liberal, they're going to pick a liberal judge. When you have a president that's more conservative, you're going to pick a conservative judge, and that they're going to sort of do their political bidding on the court. And that's not really what the framers had in mind when they created the Supreme Court. So there's some concerns about whether or not the Supreme Court is losing its legitimacy because it's seen as sort of this political or partisan institution. There also is this concern about the judicial activism. Now, a lot of times judicial activism is seen as something that liberal justices do. You'll hear liberal judicial activists, right? What an activist is just somebody who's willing to overturn laws that they view to be unconstitutional. In a moment, we're going to be talking about one of the major powers of the Supreme Court, which is the power of judicial review. And so the power of judicial review is where the Supreme Court can find a law unconstitutional and therefore nullify it or invalidate that law. And that's what it means to be an activist. Conservative justices are activists, so are liberal justices are activists too. However, there's this concern of is that really the role of the Supreme Court? Shouldn't the Supreme Court maybe be more like apprehensive or only overturn law really when it's just fundamentally necessary to view a law as unconstitutional and therefore null and void? So there's this concern that the Supreme Court is acting more like a legislative branch rather than an objective caller of balls and strikes, like a more of an umpire. There's also concern that landmark cases are often decided by one vote. We have 9 justices on the Supreme Court. And you look back at some of the more controversial cases, such as Citizens United, which dealt with the role about whether corporations can spend unlimited amount of monies creating political communications. Shelby County versus Holder, which is a case that took away some of the power of the Voting Rights Act. And Obergefell v. Hodges, which granted the constitutional right for gay and lesbian folks to get married. All of those were 5-4 decisions, right? And so rather than the court sort of acting unanimously, right, sort of seeing, of course, these laws are unconstitutional, right? It's just one justice, one way or the other, determines which way the case is going to go, right? If one justice had gone the other way in Obergefell v. Hodges, then gay and lesbian folks wouldn't have a constitutional right to be married. So there's some concerns about the splits, the partisan lines, and how young justices are becoming in terms of their lifetime appointment. And so with the court split on partisan lines, these lifetime appointments take on more significance. It becomes more political. And there's this sense that maybe that the court is becoming too politicized and that as a result is maybe losing some of its legitimacy. Well, recently there have been some suggestions on how to address the partisan nature of the Supreme Court and to basically sort of reduce the partisan temperatures that seem to be sort of arising around Supreme Court nominations and confirmations. And this isn't unique to the Trump administration. I mean, the same thing has been happening for a long period of time. So within the last 30 years or so, nominations and confirmations of justices 30 years ago, like 30, 40, 50 years ago, they were not partisan endeavors. But, for the last 30 or so years, they've just become very partisan. And so there's some concern and recommendations or suggestions for how we could reduce the temperature, right? Make the Supreme Court nomination and confirmation process less partisan, less political, and bring it back to a more sort of normal level of objective analysis of who should be justices. You're going to be reading the article Why the Supreme Court Needs Term Limits by the political scientist Norm Ornstein, and he makes some kind of interesting suggestions. He thinks that we should institute term limits for appellate and Supreme Court justices. And his thinking is that rather than having Supreme Court justices have a lifetime appointment, he thinks that Supreme Court justices should serve one 18-year term. And that there's a limit. It's non-renewable, right? So you serve for 18 years, that's your term on the court, and then you're off the court, right? And then he also thinks that we could stagger it. So once we started with the term limits, we could stagger it so that we would know that a judge would be done with their term at the end of their 18 years. That would open up vacancies on the bench. And as you institute this plan of term limits, you could do it in such a way that you could guarantee that every president in one term of office would get only 2 appointments, right? And so right now, the way it's set up, some presidents get like 1 appointment, right? I think Jimmy Carter had 1 appointment during the course of his presidential term. President Obama served 2 years and he got 2 appointments. And President Trump, in serving his one term, and we don't know yet, as I'm recording this, whether he's going to be reelected or not, but in his first 4 years, he got 3 appointments. And so the thinking here is to sort of level the playing field, that every president gets 2 appointments, and that kind of ratchets down the temperature a little bit. That is, if a Republican wins the presidency, you know they're going to get two appointments. If a Democrat wins the presidency, you know they're going to get 2 appointments. And so there's less of this like life or death sort of aspect of the judicial appointments process. Just think of yourself, well, what are some of the benefits and what are some of the drawbacks of the proposal that Norm Ornstein makes? One of the benefits is this sense of that it lowers the partisan temperature, thus maybe renewing the Supreme Court with some sense of legitimacy. That it gives older justices a chance to serve. Right now, since this is a lifetime appointment, there seems to be this movement to nominate younger and younger justices so that a president can leave their legacy on the court. Well, that leaves out like a lot of experienced justices who are older in their 60s, and maybe those are the types of justices we want on the court. Could also have more diversity as well, more open seats, so there's more turnover in terms of who gets to serve on the court. And you'll notice that Norm Ornstein's argument is for there to be term limits on the appellate court as well, thus providing that more churning of turnovers as well. And you think about what some of the drawbacks here. Well, one major drawback is we'd have to amend our Constitution if we adopted this, and that's not likely to happen. You would also deny a justice this opportunity to have this long-lasting legacy, this long term on office, where they're actually able to create sort of a legal legacy, such as Earl Warren with his legacy on civil liberties, or Anthony Kennedy and his legacy on expanding the rights of gays and lesbians. And so there are others too to consider as you're reading that article. The last thing we're going to talk about this in this lecture, and I'm sorry this is maybe longer than some of our other lectures, but there's just a lot to cover with this Supreme Court. The last thing we're going to talk about is the power of the Supreme Court. What is the power that it wields, right? Probably the most important power of the Supreme Court is the power of judicial review. And what judicial review is that the Supreme Court can invalidate the actions of Congress, of the executive branch, and states if these actions are deemed unconstitutional. So when the Supreme Court reviews cases and considers the constitutionality of the laws that are being evaluated, or the actions that are being evaluated in these cases, if on a review they find that these laws and actions are in fact unconstitutional, those laws are nullified by the Supreme Court. They are no longer have the force of law. And that's a huge power. It's not a power that's found in the Constitution. It is a power that is established by an actual court case, an early court case, early on in our nation's history, called Marbury versus Madison, decided in 1803. And look at there, you get a picture of a lame duck, right? It's a duck that has a cast on its leg. Now, we know what a lame duck is. A lame duck is when you have a president who was not reelected to the office, but they still have from November until January to serve. And in this case, in 1803, they served from November all the way until March, because the new president didn't come until March. And also we can have lame duck Congresses too, sort of like, hey, they lost their jobs, but they're still serving for a couple more months, and so they can maybe take action as lame ducks that they wouldn't otherwise do, because they're not going to be held accountable to the voters. Well, you might be asking yourself, what do lame ducks have to do with Marbury versus Madison? What does it have to do with judicial review? Well, let me tell you, and I'll try to do it as quickly as possible. Marbury versus Madison is oftentimes known as the case of the midnight justices. And that's because it was at the last moment that a bunch of justices were supposed to be placed on the courts, the federal courts. And to know, let me just put these pictures up here and so that we can sort of get an idea of what's going on in this case. So Marbury versus Madison is actually a result of the first election we had in the United States that involved political parties. It was the election of 1800, and it was a battle between John Adams on the one, he's on the left-hand side there, and Thomas Jefferson. Up until the election of 1800, there weren't political parties that candidates didn't align themselves with political parties. When Thomas Jefferson ran for president, he ran as the Democratic Republican. Okay, and so this is the first time that one party, the Federalist Party, loses and a new party comes in, the Democratic Republicans that are created by Jefferson. Well, as you can guess, John Adams, who was a Federalist, he wasn't happy about losing to Jefferson, this Democratic Republican. You think the election between Biden and Trump is filled with like vitriol and hate and seething with dissatisfaction? Man, the election of 1800 was like similar to that, if not worse. There really was a sense that if Adams won a second term, it would be the end of our republic. And if Jefferson won a second term, for God's sakes, he was an atheist, they thought that it would be the end of our republic, right? And so when Jefferson won, it was like a huge deal. And John Adams and the Federalists were like, okay, we lost, but we ain't going to go into the sunset like lightly. We're just not going to ride off into the sunset all happy. They said that, you know what, we're going to leave our legacy here. And the way that we're going to leave our legacy is that we're going to pack the courts. And that's exactly what John Adams and the Federalist Congress did. They were lame duck Congress, lame duck president, and they passed several judiciary acts that expanded the size of the federal courts and created new courts in the District of Columbia, including Justice of the Peace courts, okay? Their thinking is that we're going to create these new courts and we're going to pack them with Federalist judges. Ha ha, take that, Jefferson, you Democratic Republican. And that's exactly what they did. And so they actually packed the courts with a bunch of Federalist judges. But they forgot to deliver the commissions, right? You actually got to give a judge a commission saying you are a judge. They forgot to deliver all the commissions. And that's where William Marbury comes in. William Marbury, underneath John Adams there, he was supposed to become a federal judge, but the commission making him the federal judge was never delivered, so that he basically was never seated as a federal judge. And he was really pissed off about that. He was like, dude, I got confirmed. I should be placed on the court, but I never got my actual commission to serve. And so he basically said that he was angry about that. He went to the Supreme Court and he asked the Supreme Court to force Jefferson and his Secretary of State, James Madison, to deliver the commission. When Jefferson and Madison took office, they actually went in the office and they saw that there were these federal court commissions that had never been delivered, one of which was supposed to go to William Marbury. And they were like, screw it. We're not going to deliver these commissions because we don't want more Federalists on the court, right? And so they refused to deliver them. Well, William Marbury said that there was a federal law in the books that said that the Supreme Court could force federal officers like Jefferson and Madison to do their job. It was called a writ of mandamus. They were like, hey, and so William Marbury was like to John Marshall, he's the dude in the middle there, he's the Chief Justice of the Supreme Court. He's basically saying, hey, Chief Justice, force Jefferson and Madison to deliver those commissions. Well, John Marshall knew that he couldn't do that. He could have asked Jefferson and Madison to do that, but they would have given him the middle finger. They would have said, make me, right? And it would have shown the weakness of this new court, right? Or it's only 1803 here. And so John Marshall came up with this way around it. And what he did was, as it says there, is that John Marshall, this new Supreme Court justices, he looked at the law, okay? It was the Judiciary Act of 1789 that gave the Supreme Court this issue to force Jefferson and Madison to deliver those commissions. It was called this writ of mandamus. He looks at that law and he says, aha, that law is unconstitutional. There's nothing that gives Congress the power to tell the Supreme Court that it must enforce a writ of mandamus. And that's where judicial review is born. He's basically saying, I'm sorry, William Marbury, but that provision in the Judiciary Act of 1789 is unconstitutional. Therefore, it's null and void because Congress can't tell the Supreme Court what its jurisdiction is. And so out of this midnight justice's case it's such an important case, not because of the lame ducks and not because of the battles between the Federalists and Democratic Republicans, but it's important because this is where judicial review is born. So here are some examples of the different types of judicial review. So the Supreme Court can, on reviewing acts of and laws of Congress, acts of Congress, right? They can look at those federal laws, and on review, if they find that they're unconstitutional, they can invalidate those laws. Citizens United versus the Federal Elections Commission is a good example of that. In the late part of the 1990s, early part of the 2000s, there was a move within the United States Congress to reduce the amount of spending that was being the money that was being spent on federal elections. There was a sense of that there was way too much money being spent in federal elections, and it was that big spending of money was sort of corrupting federal elections. And so the Congress passed what we call the McCain-Feingold law, right? But formally it's known as the Bipartisan Campaign Reform Act. And one of the provisions in that Campaign Reform Act was saying that corporations could not spend an unlimited amount of money on creating political communications. Okay, it basically restricted a corporation's ability to communicate its political beliefs by creating political communications. And Citizens United had created this movie. It was called Hillary the Movie. And it was a movie that was talking about how awful Hillary Clinton would be if she became president of the United States. If you recall, Hillary Clinton ran against Barack Obama in 2008 in the primary and lost to Barack Obama. And so this movie was designed to communicate Citizens United's perspective that Hillary would be bad as president. Well, they were fined for violating the Bipartisan Campaign Reform Act because that act said that there were limitations on the amount of money that corporations could spend in political communication. And so Citizens United sued and said that that provision of the Federal Campaign Reform Act was unconstitutional, and the Supreme Court agreed. The Supreme Court said that the First Amendment's freedom of speech provision protects the freedom of expression of corporations, that people can express themselves and so can corporations. And in fact, you can't put limits on the amount of money that corporations spend in order to communicate their political message. And so that's an example of the judicial review, because that provision of the Federal Campaign Reform Act was nullified. Earlier, I had talked about the judicial review and presidential power, the actions of the executive branch. The case Hamdi v. Rumsfeld is a good example of that. I'd mentioned it before. Hamdi was a U.S. citizen who was fighting with the Taliban in Afghanistan. He was taken as an enemy combatant, and he was denied habeas corpus rights. He wasn't told why he was being charged. He was being held indefinitely. He was denied a right to counsel, etc. And Hamdi sued, saying that as a U.S. citizen, he could not be denied those rights. The Bush administration and the Department of Defense said doesn't matter whether he's a U.S. citizen, he's an enemy combatant, and enemy combatants don't have those rights. Well, the Supreme Court disagreed. They said that the actions that the Bush administration took in denying Hamdi his habeas corpus rights was unconstitutional, and so it nullified that executive power, and the executive branch had to give Hamdi respect his rights of habeas corpus. The Supreme Court, because of the Supremacy Clause, can also nullify state and local law, since the United States Constitution is the supreme law of the land, that if state and local laws violate the Constitution, they can be nullified by the Supreme Court as well. Here's two examples, Roe v. Wade and Obergefell v. Hodges. Remember, Roe v. Wade is about a Texas law that criminalizes abortion, and the Supreme Court said that that state law and all state laws like that are unconstitutional because they violate a woman's right to privacy. In Obergefell v. Hodges, that is about states that define marriages between a man and a woman, and in Obergefell v. Hodges, they found that those state laws were unconstitutional because they violated the Equal Protection Clause and also because they violate a person's fundamental right to privacy. So, in conclusion, I just want you to think about critically thinking about judicial review, and a question like this will come up on the final exam. So there, should an unelected judicial body like the Supreme Court have the power to overturn the actions of elected legislative bodies, right? I mean, basically, you can have 5 people on the Supreme Court who overturn an act of Congress. I mean, and that would be 535 members of Congress. Theoretically, there could be unanimity on passing a law. But if the Supreme Court views it as unconstitutional, 5 people can overrule the voices of many. Is that democratic, small d, or is that like an abuse of power? Should the court defer to the legislatures, letting them resolve most disputes over law? We sort of saw this come up in the Amy Coney Barrett hearings. She was critical of the active use of judicial review. She was really saying that, like, look, the Supreme Court doesn't always have to step in and settle disputes. If states want to define marriage a certain way, let them. If states want to, legalize or not legalize abortion, let them, right? And so we should defer to legislative bodies. Does judicial review sort of make it so that it enhances and inappropriately enhances the power of the Supreme Court? Are there any checks on the Supreme Court judicial review? Are there adequate checks to prevent the Supreme Court from abusing its power? We talked earlier that one way you can check a decision of the Supreme Court is a new Supreme Court rule. And so if the Supreme Court views a law as unconstitutional, a new Supreme Court could come and say, no, you're wrong, that it is in fact constitutional. And so, or vice versa. And so, maybe that's an adequate enough check. You can amend the Constitution, and that would be a check as well, although we know that it's really difficult to amend our Constitution. And finally, just what are some of the benefits and drawbacks of the Supreme Court exercising its judicial review? Thanks for hanging with me here. I know this was a longer lecture, but judicial review is incredibly important, and the Supreme Court is incredibly important. So thanks for listening to the entire lecture.